So, for today's topic, we will discuss about section 19, which is about trial. So, the assigned topic was section 23 and section 24. Section 23 is about the mirror of to evidence, or simply means a motion to dismiss. So, what is demurrer to evidence? It is called a demurrer to show that the evidence was filed after the accused has presented evidences. After the prosecution is its case, or simply means that the prosecutor finished presenting its evidences on the court on behalf of the accused. Then the court may dismiss the action on the ground of insufficiency of evidence, or just only one ground, or lack of evidence presented during the trial. So, when a demurrer can be filed, it must be filed within an unextendable period after the prosecution rests its case. So, what is the goal of demurrer? The goal is to dismiss the case without the defendant having to present any more evidences during the trial. So, next topic is about what if the demurrer of the accused is denied. So, filed with leave of court or permission of court. In this way, the accused may adduce evidences in his defense. The accused can present evidences if his demurrer is denied. As permission to the court, it allows the defendant to present their evidence, preserving the right to further defend their case. Number 2 ways is if it filed without the leave of court, or the accused waives the right to present evidence. In this way, the accused has no rights to present any more evidences on his behalf, and there is now judgment, or the judge will now render judgment. The accused asked permission to court, and the demurrer was denied. The accused waives the right to present evidences, or the accused do not have the right anymore to present evidence against another parties. So here an example about the summary to demurrer to evidence. So number 1 is the prosecution rested the case. It means that when the defendant presented all its information, all evidences in front of the court. So there are 2 ways. Number 1 is the defense may present evidences, and number 2 is the defense may file demurrer to evidence. In defense may file demurrer to evidence, there are 2 ways again, namely filed with leave of court and filed without leave of court. In filed with leave of court, the accused may present more evidences to defense its right to trial. The second one is filed without leave of court, or in this stage, the accused has no right to present more evidences, and the judge will render a judgment. So in this, we both see that both are being denied. So proceed to the accused may adduce evidences, and the accused waives the right to present evidences, or it has no more right to present evidences in front of the court. So here is the period of filing of demurrer to evidence. The defendant may file a demurrer to evidence after he has completed to present all his evidences and rests its case. Second, the opposing parties also has 5 days from notice to file an opposition, and the court has 15 days to resolve it. So, if the court grants the motion to evidences, meaning it approves the motion. The accused will have 10 days to file the demurrer, and the prosecution will also have 10 days to file an opposition against the accused. So the topic is all about section 24, or the reopening. In this section, at any time of finality or before judgment of conviction, the judge may motu proprio or upon motion with hearing in either case the proceedings to reopen the proceedings to avoid miscarriage of justice. The proceedings shall be terminated within 30 days from the order granting it. So, are the person authorized to file motion to reopen? Number 1 is the judge. Second is the prosecutor, and third is the accused.
Good day everyone, my name is John Paul Erapal, and to our subject teacher, Attorney Beverly Boricao. And let's start to my presentation agenda. It's Rule 119, the trial, and this is the disseminated to our group. Start with Section 23, demur to evidence, and Section 24, the reopening. Section 23, demur to evidence. After prosecution rests its case, the court may dismiss the action on the ground of efficiency of evidence on its own initiative after giving the prosecution the opportunity to hear or upon demur to evidence filed by the accused with or without leave of court. What is demur to evidence? It's a move made by the accused after the prosecution finish presenting its case. They saying even everything the prosecution said is true, there's still not enough evidence to convince me. If the court denies the demur to evidence filed with leave of court, the accused may adduce evidence in his defense. When the demur to evidence is filed without leave of court, the accused waives the right to present evidence and submits the case for judgment on the basis of evidence for the prosecution. And the motion for leave of court to file demur to evidence shall specifically state its ground and shall be filed within a non-extendable period of 5 days after the prosecution. Rest, it's the case the prosecution may oppose the motion within a non-extendable period of 5 days from its receipt. Filing the demurrer, the accused can do this either with or without the court's permission. If they get permission and the court says no, they can still present their own evidence. If they don't get permission, they can't present their own evidence. And the timeline of demur to evidence, the accused has 5 days after the prosecution finish to ask for permission to file the demurrer. If allowed, they have 10 days to actually file it, and the prosecution gets the same amount of time to respond. If leave of court is granted, the accused shall file the demur to evidence within a non-extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within a similar period from its receipt. And the order denying the motion for leave of court to file demurrer to evidence or demurrer itself shall not be reviewable by appeal or certiorari before judgment. And the final decision, whatever the court decide regarding the demurrer can't be appealed until after a final judgment is made in the case. And that's all about section 23. Proceed to section 24. Section 24, reopening. Any time before finality of the judgment of the conviction, the judge may motu pro reo of upon motion, with hearing either case reopen the proceedings to avoid a miscarriage of justice. The proceeding shall be determinated within 30 days from the order granting it. The reopening is all about if there's a chance that something went wrong during the trial and it might lead to an unfair verdict, the judge can decide to reopen the case, and this can happen if the judge decides on their own or someone asks. There will be here to discuss this and purpose for our reopen. The main aim is to prevent any mischarge of justice, ensuring that the right decision is reached in the end. And the timeline for the reopen, once the decision to reopen is made, everything has no wrap up within 30 days from the point, making sure there's no unnecessarily delay in resolving the matter. And that's all. Thank you.
Good day, ma'am. My name is Gerald Ramos from Blacto. I will discuss my science topic, Rule 119, Section 23 and 24. Section 23, demurrer to evidence. After the prosecution reaches its case, the court may dismiss the action on the ground of the insufficiency of evidence. On its own initiative, after giving the prosecution the opportunity to be heard to upon demurrer to evidence filed by the accused with or without leave to court. If the court denies demurrer to evidence filed with leave of court, the accused may adduce evidence in his defense. When the demurrer to evidence is filed without leave of court, the accused with the right to present evidence and submit the case for judgment on the basis of the evidence for the prosecution. The motion for leave of court to file demurrer to evidence shall especially state its ground and shall be filed within a non-extendable period of 5 days after the prosecution rests in case. The prosecution may oppose the motion within the non-extendable period of 5 days from its receipt. If leave of court is granted, the accused shall file the demurrer to evidence with a non-extendable period of 10 days from notice to prosecution. By may oppose the demurrer to evidence within a similar period from its receipt. The order denying the motion for leave of court to file demurrer evidence or demurrer itself shall not be reviewable by appeal or by certiorari before judgment. Explanation. A demurrer to evidence is a legal motion made by the accused after the prosecution has presented its case, claiming that uh, evidence presented by the prosecution is insufficient to prove the accused's guilt beyond a reasonable doubt. The accused can file demurrer to evidence without leave of court. If filed with leave of court and the accused can then present evidence in their defense. If filed without leave of court, the accused with the right present evidence and case is submitted for judgment based on the prosecution evidence. The motion or leave of court to file and demurrer to evidence must be filed within 5 days after the prosecution recent case, and the prosecution can oppose within the 5 days of receiving the motion. If leave or court granted, the accused must file the demurrer within 10 days, and the prosecution can oppose within the similar period. It is important to note that the order denying a motion for leave of court of file demurrer to evidence or the demurrer itself cannot be appealed or reviewed before judgment is rendered. This means that the decision of the demurrer to evidence is final and cannot be challenged through an appeal or certiorari before the case is concluded. Next, Section 24. Reopening. At any time before finality of the judgment of conviction, the judge may move to preview or upon motion with hearing in either case reopen the proceeding to avoid the miscarriage of justice. The proceeding shall be terminated within 30 days from the order granting it explanation. This section of the law allows the judge to reopen the proceeding of the case before the final judgment of the conviction is issued if there is a concern that a miscarriage of justice may occur. This can be done either on the judge's own initiative or in response to a motion filed by either party. If the judge decides to reopen the proceeding, a hearing will be held to investigate the issue at hand. The purpose of reopening the proceeding is to correct any error or there's any new evidence that may have come to light that could potentially change the outcome of the case. It is important to note that the proceeding must be complete within 30 days from the order granting the reopen in order to ensure that justice is promptly preserved. This provision is intended to safeguard the right of the parties involved and ensure that the legal process is fair and just. Thank you.
Good day everyone, my name is Marco James Bertuccio of Block 2 Base Criminology 4th year, and today I'm going to discuss the Section 23 and Section 24 of the Rule 119 or the trial. So first, I'm going to discuss the Section 23, which is all about the demurrer to evidence. So when we say demurrer evidence, it is the proposal to dismiss the criminal case because the evidence submitted by the prosecution does not prove the crime. Okay, I will explain it furtherly. So I will give you an example. For example, Mr. A filed a case for Mr. B, but during the prosecution, all evidence that presented by Mr. A against Mr. B are not relevant or does not support the particular case. So, the accused has the right to file a motion for demurrer to evidence in the ground of insufficient of evidence. And if granted, the court will acquit the accused without the need for the defense to present its evidence. Let's proceed to Section 24 or the reopening. So it means at any time before the finality of judgment of conviction, the judge may motu proprio or upon motion with hearing in either case. And it is very important to reopen the proceedings to avoid a error made by the court that sometimes results in the conviction of an innocent person for a crime they did not commit. Thank you.